Next, we have the very good fortune of welcoming our next two speakers, Mary Jane Dykeman and Angie Hamilton, who are joining us this morning. In the interest of time, I have to keep their intros short, but I can promise you that I am not going to do justice to the amount of expertise and knowledge that these two women are bringing to the table. So please go to our conference website and read their full bios. Mary Jane is a partner and co-founder at INQ Law in Toronto. She has acted as in-house general counsel to 2 Toronto teaching hospitals, and she regularly assists healthcare organizations, many different kinds, including mental health and addiction agencies, to find practical solutions to legal, clinical, risk, and privacy matters, including mental health, consent, capacity, and substitute decision-making. Angie is the executive director and co-founder for Families for Addiction Recovery. And Adriana is going to give us a link in the chat to that organization. For those of you who aren't aware, please go over there to visit Families for Addiction Recovery. She's a retired lawyer and a caregiver herself. She represents Families for Addiction Recovery on the Toronto Drug Strategy Panel of Toronto Public Health. She is a board member of the Ontario Family Caregiver Advisory Network and a member of the Public Policy Committee of the Canadian Society of Addiction Medicine. Mary Jane and Angie will be talking to us today about consent, the Mental Health Act, and strategies for being an advocate in the system. And just a reminder to everyone, we want to keep these sessions quite interactive. So I see folks are using the chat, which is wonderful. Keep that going, keep that alive and kicking. Provide us your thoughts, provide us your feedback and your questions. We've asked Mary Jane and Angie to save some time at the end for questions. So feel free to pop that question in the chat and I can read it out loud at the end. Or if you feel comfortable, you can raise your hand and unmute yourself and ask your question. Without further ado, I'll pass this over to Mary Jane and Angie.
Hi, everyone. I'm going to kick it off. I'm Mary Jane Dykeman. Thank you for the kind intro. I mainly work in hospitals, community mental health and addiction agencies and across the system on behalf of the healthcare providers. But I've seen a lot over 20 plus years. I started my career out at the Ministry of Health back in the day when they were running the 10 provincial psychiatric hospitals. I went in-house at the Psychiatric Patient Advocate Office, probably late 90s. So it's a long time ago. And yet all of us step into the role of caregiver at one point or another. I imagine that some of you are wearing dual hats. You may be dealing with a spouse, and you may be supporting elderly parents. You may be walking through the system with children. So it is ongoing all day, every day. My sister and I did walk that route and said to one another one day, oh my gosh, we're the adult children, because usually in my work, she also works in healthcare. In my work, I'm used to helping some of the organizations deal with thorny situations. And I ask two questions quite often. Is the person we're talking about capable? And as you know, and as Angie and I have talked about for a long time, we'll be talking about today, there are many rights attached. If a person's capable, just as any of us could make a poor decision, they get a lot of rights. And it has been controversial over time. Some of the best encounters I've had sitting in some of these thorny situations over time have been where we say out loud, you are the expert in your person. And the healthcare providers have their expertise, thankfully. And this is from a healthcare lawyer who isn't a clinician, although I'm going to make a couple of comments later that I'm starting to look at some of these clinical issues. You are the expert in your person. And we know sometimes that people, I'm all for the rights of people. And I know we're even going to get down in the weeds on a Saturday morning in the fall, talking about the charter. What does it mean? Where has it been? Where could it go to also assist the situation? Anyway, I think it's pretty imperative. I'm going to walk through a bit of the Mental Health Act. You'll see in my resources, I put up the Mental Health Act. That's the main focus. We'll talk a little bit about consent and we'll touch on privacy. I know you're going to have a great session in a week, so I only highlighted a couple of key things in red because the three are really interlinked. So your deep dive is next weekend on PHIPAA, the Health Privacy Legislation and Healthcare Consent Act. And we'll talk about a few of the intersections today. So it'll just be a bit of a primer of also what's to come. And then the last thing I'll say before I jump into this is I recall many years ago being at a Schizophrenia Society of Ontario conference, and it has stayed with me all these years because all of the questions from the crowd were from caregivers and people really suffering themselves for the system as it stood then. I would love to say that it's all been solved. I will say that over the years, there's been more attention to mental health and addiction, more attention at the other end of the spectrum to seniors issues. Maybe things have gotten better, but I'm sure your experience is such that it remains a struggle. And navigating the system is not easy and the supports are not there. And then when you look at things like the privacy barriers and everything else, I did work on PHIPAA. That was my first file when I went in-house to the Ministry of Health in the summer of 1995. It took 9 years to get that legislation in place, hopefully not because of me. But it does create some barriers. So I want to talk about a few tips as well at the front line. How do you get someone to listen to you? Because there are rules about people not being able to collect information from you except in limited circumstances. And then I guess my legal comment is you have to be the squeaky wheel, but how do we also support you? The two questions that I come back to are, is the person capable? Because that's going to change the thing. I don't take the fact that someone's capable as a hard stop. And I've been trying to train healthcare providers to not see things as a big stop sign. Hey, would you like to share information with your parent? No? Oh, then we never talk about it again. That's not nuanced at all. So let's just talk for a minute about the Mental Health Act. And I'm actually going to ask you to watch time. I don't want to reduce my screen in case it disappears. I realize I didn't bring my phone with time, with the clock on, and there's nothing like a lawyer wanting to talk about some of these issues. I could do this in 3 days, or I can do it in the half hour that I'm allotted. So keep me on track.
We'll keep you on track.
Yes, please. So some of this will be known to you. Some of you will have lived it in a cycle. That's the nature sometimes of mental health, that you're in it. Maybe at some point the person is in hospital, in a psychiatric hospital. And again, that is either a mental health unit in what we call a Schedule I facility, or it could be a standalone mental health facility like the Center for Addiction and Mental Health or others, a few others around the province. Everything in the Mental Health Act is prescriptive. There are all of these duties that the officer in charge under that act, they have to cross every T, dot every I. If they don't, a form could get kicked out immediately. It'll be flawed and kicked out. That's extremely frustrating for families, right? When it's finally going well. And then it turns out something about the date wasn't written properly. So we do a lot of training of staff in the hospitals. Okay, we've got to get this right, or else we're going to find ourselves, maybe at the Consent and Capacity Board, which is an arm's length tribunal. Some of you may have been there. And that's the other thing. Under the Mental Health Act and under the Healthcare Consent Act and under PHIPAA for health privacy, people get a lot of rights, and they often can go and appeal even if there is a finding that they're incapable or they need to be involuntarily detained or they lose their ability to manage property. And so on the one hand, I get it, but at the same time, it's not even cohesive in terms of what's the legal test for whatever this kind of incapacity is, who is making that decision about the person. Is it a physician who's proposing treatment? Is it someone else in the mix? And then where do they have rights to go? Ultimately, I guess here's the legal answer. It depends. But anyway, let's just pull the lens back a little bit. 3 ways to get someone to hospital. Any physician who's seen the person within 7 days can sign a Form 1, the application for psychiatric assessment. Any physician, it's not any psychiatrist. If that were the case in many parts of the province, we would have real issues. But sometimes no physician has seen your person. And so you may not be able to go the Form 1 route or convince a health practitioner that that's necessary. If they haven't seen a physician, it can't. I think some rules may have changed in COVID. They have to have seen them. Usually that meant in person. In COVID, I think that's changed a bit, but they can't have had no contact with a physician within the past 7 days to start to affect that. If that were the case, I guess the next thing, and one of the scenarios I bring up is, okay, well, maybe you get the person to hospital, but that also is not always easy. And it's not always a guarantee that the person is going to stay. Even if they get onto a Form 1, even if, I think it's Section 15 of the Mental Health Act, they get assessed they have to be seen by 2 physicians. That's another protection the law gives them. First physician will decide whether they meet the criteria. We're going to talk about the criteria to even be assessed and placed on a Form 1. And what does the Form 1 give you? Up to 72 hours, but it's up to 72 hours. So sometimes families, caregivers are thinking, even if we successfully get the person onto a Form 1, okay, here's the respite. They'll be in hospital at least for 72 hours, even if they're not admitted. And then that doesn't happen. They may be back on the doorstep, as it were. So there's Form 1. That's the one that many caregivers, and you can tell me otherwise by all means in the chat. That's the one, in fact, I didn't put the chat up, but I'll do that right now and get it out of my way so I can still see. That's the one that most caregivers seem to prefer because, again, it's arm's length. It is not the family having to go, figuring out the justice of the peace process under a Form 2, gathering all of the evidence to go and convince a justice of the peace to sign off that the person is apparently, because a justice of the peace isn't a clinical person, that a justice of the peace is going to say that they're apparently suffering from a mental disorder that is driving certain behaviors that could lead to harm to self, others, or serious physical impairment. We're going to come back to that. So Form 1, physician, sometimes, and again, Form 2, sometimes families or even the healthcare providers who could also go get a Form 2, and some agencies do. Sometimes they'll just say, that's going to harm the relationship, either the clinical therapeutic relationship, if it's the healthcare provider, let's say a mental health agency staff, or with you. It just looks like a more overt step, but it is there. It's an authority under law, and you may or may not have success on that front. And then the third option is, sure, it could be waited out until there's an actual reason to have police in. Police under the Mental Health Act have powers under Section 17 to step in and sort of flow someone down in through the Mental Health Act. And then the other thing that we're not going to talk about today, it may be touching some of you, is that there's the forensic mental health system. So the way I would describe it is, if you call police about my behavior, police come, they could simply put me into the regular criminal system, the justice system that is, and go that path. Or they may think, there's something here in terms of a potential mental health issue, and they could stream it through the Mental Health Act. We think of that as a civil system. Or they could charge me with a crime under the criminal code, and then at some point there'll be a decision, regular criminal justice system or the forensic system, which is for a person who's committed a crime, but we're now in a mental disorder situation. And even if someone goes all the way through the criminal system, they could come out the other end and be found not guilty by reason of mental disorder. But we're not doing a dive into the forensic system today. So 3 different ways, and we can talk about the strategy of how do you actually get the person to hospital. I'm just saying this is a sufficient legal authority comes from this. If a Form 1 is signed, that's enough authority for police to come and take the person. Form 1, as I said, lasts only up to 72 hours. So that's if the physician under Section 15 of the Mental Health Act believes that there's reason to sign the Form 1, again, has to have some thought that there is mental disorder that's driving these behaviors that are either resulting in harm or could result in harm to self or others, or serious physical impairment I want to talk about because sometimes that one is not brought forward. Talk a bit later about there's another criteria, and I think Angie's going to review it as well. So that what I'm talking about is considered the box A criteria. There's another box B. And I was thinking, oh, it's more recent. Well, it was actually 2000 when the Mental Health Act changed. In the year 2000, and again, 2 decades ago, we changed the Mental Health Act to bring in community treatment orders. We changed it to create a box B to have a link to people who've been in hospital before and who've had treatment. And then, because again, there's a cycle, right? Maybe they go in, maybe they were treated. And we're going to talk about the hurdles that come with that. Because in Ontario, we've separated the Mental Health Act from the Healthcare Consent Act. Out in BC, it's not separate. The medical director in a mental health facility has the authority, if you're involuntarily detained, to order treatment. We don't have that here. And that's probably a question that many of you have. Just one more note on the up to 72 hours. Again, we've had families surprised because maybe there's been a long road to even get to that point this time again, and that cycle continues, right? Person goes in, maybe they get treated, then they stop taking the medication, and then they come out, and then we're in it again. Up to 72 hours, though, the one thing I do want to point out, we're going to talk, and I'm sure you'll be talking again in a week, about the flow of information and the barriers that you may face sometimes under PHIPAA, the health privacy legislation. When a person is on a Form 1, there's authority, and it's written right on the Form 1, for the healthcare provider, let's say the emergency room doc or the family physician or whoever's seen the person within 7 days, they can collect collateral information from you. That is one of, and this is one of the things we want to do today, is really to have a look and think, where are the touch points, either real or of your making, where you can get the information into the hands of the people who really need it, because PHIPAA can be quite strict about what the healthcare provider can collect. On a Form 1, ability to collect collateral information, I've always said, caregivers, keep the detailed notes and then have your elevator pitch ready. If you get that opportunity, when the person is on a Form 1, if there's a way to provide that information, that is one of the things. Anyway, it's not a perfect system. And sometimes, I'll be frank, sometimes the healthcare providers also don't quite know the rules as well. Sometimes that works in your favor because they don't know about the restrictions on what they can collect. Other times they'll shut you down. So just thinking about what are the touch points along the way. Person's not yet a patient, but I don't know that that really matters. They're still there, but they're not a registered patient yet. They don't get rights advice on a Form 1, but they are detained. They are detained for up to 72 hours to be observed, examined. They're going to be examined by a second physician, especially with substance use. Sometimes they'll go in, do an initial assessment, step out, let some hours pass, go back in just to see where they are. I've already mentioned that I'm always encouraging and training the healthcare providers to make sure that documentation has been reviewed, that it's complete, because people do get rights advice. Rights advice in Ontario that's not the same rights information that you and I would get if we went to a physician. If my family doctor proposed a treatment under the Healthcare Consent Act, they have a duty to give me what they call rights information so that I know the risks, the benefits, et cetera. Rights advice is more formal. It's given mainly to people in a mental health facility and upon a change of legal status. So there are many changes of legal status. Again, as I mentioned, if you lose your ability to manage your own property, if you lose, or if you are involuntarily detained, if you are made incapable to consent to treatment, there will be a formal rights advisor called, and they come from the psychiatric patient advocate office, and they come and sometimes they're able to give the rights advice depending on how the person is doing. Maybe they're in acute, florid state of psychosis, and the rights advisor will then come back. But that's by law. And I know sometimes it's frustrating to families. I've had a family member with dementia. And there was a proposal a few years ago, it's still on the books, but it's not law, about confinement, where you can, because by law, for example, a long-term care home is not a detention facility. It's not like the Mental Health Act. And I remember they were proposing that all of a sudden we'd be giving a lot of rights advice to seniors, including with dementia, which makes sense on the one hand, and we're all for the rights of people. But I remember thinking from a personal point of view, and as a caregiver, I was thinking, my gosh, my person's gonna, I guess it does reveal the gender, put a purse over her shoulder and walk right out the door. So sometimes the law does not reconcile entirely with the lived experience of being a caregiver. I'm going to skip the Form 42. It's all to say there are a lot of things that have to happen. There are certain forms that have to be given to the person. If the hospital doesn't get it right, it can void the whole process. And then, sometimes you're starting over. I don't go to the consent and capacity board, to the tribunal very often. Usually we're in the background trying to sort the situation, finding, an elegant way through. But it is really frustrating to families when they get the issue all the way to the board, probably because your person has appealed to the consent and capacity board. And then the whole incapacity consent to treatment, or the fact that someone was involuntarily detained, gets tossed out because, again, the date was wrong on the form, or the person didn't get the right form, or whatever it is. Police have, as I said, their Section 17 powers up front. If they are called into a situation, they can assess it and then determine whether they want to stream someone to the mental health sort of avenue. And again, I put back in red, you can provide, the police can also provide collateral information on a Form 1 assessment. So it's, how do we gather up all this information that we know would be useful to the determination? If we can't get the collateral information into the hands of the people who need it, I mean, we have that opportunity on the Form 1 if we get the opportunity. And how do we do that in COVID, for example? I mean, I would just be sending in whatever it is and call it collateral information for the Form 1. I wish it were more organized in the ways that you are able to give information to people. What you're probably finding sometimes, and we did some work for the Change Foundation on caregivers and privacy barriers, and you would think, this is my new expression, you would think that the law would give you that avenue in. It's just, how do we make it work at the front line? Like, it's nice that it says it, but how do we make it work so you get the right information to the right people? Community treatment orders, I won't spend a lot of time on, other than to say, again, 20 years ago, government decided that other jurisdictions had community treatment orders in place. I think I say in some of my later comments, the Mental Health Act is really about mental health in a psychiatric facility. Again, the mental health unit of a hospital or a standalone mental health facility, it is really not about the community. And the irony and the problem in it is so much now is happening in the community. Maybe we shouldn't be spending a lot of our time today talking about the hospital experience. I mean, you probably will touch it in and out, or maybe some of you have had your person with an extended stay, but what about the resources in the community and what guides it? But really, the exception now, as of 20 years ago, is that community treatment orders are in place. And basically, to be on a community treatment order, and maybe someone's going to propose that. So the quick 101 is, a community treatment order is not really an order. It's not like a court order. And I didn't draft that legislation. I did work on PHIPA. But I was asked to do the provincial roadshow with a psychiatrist and another forensic lawyer. And when we went around and we were introducing this framework, families were so frustrated because they kept saying, it's not really a court order. It's done on the consent of either your person, if they're capable, or more likely done with the consent of a substitute decision maker. And again, you may be talking about it next week, but just keep in mind, when does your role shift? because many of you, I mean, all of you presumably are caregivers. Some of you may or may not be the substitute decision maker under the ranking in the Healthcare Consent Act. Maybe you are, maybe you are both. Maybe you were always a substitute decision maker because already your person was incapable when they entered the healthcare system. And maybe it's you, but you may also be tangling sometimes with, hey, I've been the caregiver for all this time. My person is now incapable, let's say for treatment, and I'm outranked in the Healthcare Consent Act. We can pause on that just for a second. You're going to come back to it in a week. So sometimes you're navigating not only, maybe it's a spouse who's ranked higher than you. Maybe someone has authority in a power of attorney, et cetera. You don't have to have a power of attorney in place to even have a substitute decision maker, but you should always know who is your substitute decision maker, first of all. And if you wanted to change it, then you'd probably have to sign a power of attorney or do something else. Everyone has a substitute decision maker, but I also see tensions at that point in the journey as to whether you are going to be the person who's a substitute decision maker, or are you going to have an extra hurdle in that you're not, and yet you still are the person to whom the patient comes out of hospital, they get discharged, they come home, and maybe that person's saying, and don't share my information. And you're thinking, what am I to do? We'll come back to that in a second. So community treatment orders are an option. The person has to be eligible for a Form 1. So again, mental disorder, driving certain behaviors that could result in harm to self, others, or serious physical impairment, or the Box B past treatment and admission criteria. And part of it is if the person goes off the community treatment order, which sometimes they do, they'll just abscond, they'll take off, and there are all kinds of things built into the act to try to help the person to comply. But they, to be on it, they have to be eligible for a Form 1, which would be the path back into the hospital setting and potential admission and involuntary status. Okay, so then, as I said, it's based on consent. So really, I think to one night when we flew up to, I think it was Thunder Bay, and we had a ton of people in the room, nobody was happy because it wasn't, the caregivers were saying it has no force of a court order, it's done on consent. It could be the consent of the capable person. Most often, you don't even go to a community treatment order if you're doing that. People have asked, does a community treatment order help us jump the queue? Because a community treatment order has to be underpinned by a community treatment plan that all the healthcare providers got together, including with either that capable person, or if they're incapable, with the substitute decision maker, and then the plan gets sorted out. And that's considered to be treatment under the Healthcare Consent Act. So all those other rules and rights and everything else start to kick in. I only want to mention very briefly capacity to consent to, well, actually the management of property. So just a quick 101 in Ontario, if a person is admitted to a mental health facility under the Mental Health Act, there is an automatic requirement in the Act that the person be assessed, that their financial capacity be assessed on admission. And then it's meant to be assessed within a certain time frame of them being discharged. And this, I think, gives a little comfort to families, because some of you may be quite worried that the person is spending and acting erratically and depleting themselves, and they may have nothing to come back to eventually. But that's only if the person is in the mental health facility. If it were for you or me or for them when they are outside the mental health facility, it moves over to the Substitute Decisions Act. And even, let's say it were your elderly parent or maybe adult child or spouse or you, the law says when it goes under the Substitute Decisions Act for the regular person who's not detained in a mental health facility, if you decided, well, I'm going to bring in a capacity assessor, that's done through the Capacity Assessment Office, and there's a list of assessors. It costs money, so it's going to be hundreds of dollars. Even if you pay to bring that person has to come and sit down with your person and say, hi, I'm the capacity assessor. I'm here to assess your capacity to manage the property. Would you like to proceed? And guess what happens? Often the person goes, no, or not as nicely, no. That's a protection in law so that nobody can have imposed on them having their ability to manage their property taken away. But for families sometimes who go to the ends of the earth, they arrange this, they bring the person in, by law, that person can't force an assessment. You would have to go to court under the Substitute Decisions Act. And so I often say to the hospitals, long-term care homes, community mental health and addiction agencies, someone's probably going to court, but it's not going to be the organization. So this is another barrier in the law, I think, that just doesn't.
Mary Jane, 5 minutes, please.
Oh, perfect. So I think we've covered that. Let me see if I can advance myself. I think we've actually covered some of this. And as I said, you are going to come back to this in a week. If a person's capable, they can make what we think of as objectively bad treatment decisions, just as we can. Substitute decision makers can't really do that. I flagged at the bottom, to be a substitute decision maker, you yourself have to be willing and available. Sometimes we do chase people to step back in. And then I've said to hospitals and homes, I mean, this is not your situation, but if we need to proceed with treatment, we need to find the person who is going to come to the table, or we'll move to the next highest ranked person. You're going to come back to some of this next week. And you'll come back to the capacity test to be capable as well. PHIPAA, again, special rules for kids. I didn't put in red, but just sort of mid-page. Unfortunately, when we drafted it, we didn't just do it based on capacity. We put age in, so now it's confusing to everybody. But there are certain rules. 16 and up, someone can make their own decisions. Below 16, parent or child. In terms of, this is about information, consenting to collection, use, and disclosure, and more. Let me just do a couple of quick things. I've already covered that first one. I have a scenario in the middle about George living in his house. Adult children are starting to worry about hoarding. Hoarding is a mental disorder under the DSM-5, the American Psychiatric Association sort of compendium of mental disorders, which has changed. I know that Angie's going to come back and talk about that a little bit. He's starting to wander. So I just wanted this to be a trigger, is one of the options if you use the Form 1, Form 2, or police situation, because we think it's tied to his mental disorder. Maybe he's going out in the elements without enough clothes on in the dead of winter, and he's not, a teenager trying to look fashionable. Mental Health Act may give some tools as well. I've already mentioned the Consent and Capacity Board and the cycle that you come to. The next scenario, Liam, the fact that he's 16, means that he controls his information. The other thing I should have said about kids is the rule says, let's say that Liam consented to his own treatment or to counseling under the Children, Youth and Family Services, CYFSA, the Child Protection Statute. If he made his own decision, he makes the decisions around the information as well. If it's a camp note and the child's under 16, I could sign off on that as a parent. It could be either of us, but the child's wish prevails. And if they're capable, they can make decisions. I made a scenario of Brian set up front. I don't go to the doctor. I'm not trying to single out the men either. During COVID, imagine what we've seen in COVID in terms of navigating the system, access, resources, and everything else. He's now suspicious and hostile. Doctor saying, listen, I haven't seen him. You can't get him to me. Try to get him to the hospital, not working. She finally is able to. Police came a couple times, didn't take any action, didn't use their powers. She then gets him there, shares the information with the staff in the emergency room when he's on the Form 1. I would say even if he's not on a Form 1, even if the law says there are these restrictions on what the healthcare provider can collect, just keep telling them. When we did the Change Foundation materials, we even said, here's your script. Remind them that they have the authority to collect it if they can't get the information in a timely or accurate way. That's in section 36 of PHIPAA. You're going to come back to PHIPAA next week. Get the records of the person while they are in hospital. If they were involuntarily detained, there's a section tucked into the Mental Health Act that most people don't know about, including the practitioners, that say the hospital can share information with any person without a warrant, without consent, if they are involuntarily detained. And so you could say to them, hey, look to that. I should have looked it up. It's either, I think it's 39 sub 5 or 35 sub 9. I can send it in the chat while Angie's talking, but it's discretion for the hospital to release information to any person because when the person is involuntarily detained or if they are under the criminal code forensic provisions. Okay, I probably need one more minute. Keep in mind, and this may be your experience, sometimes your person may face not getting the healthcare they need because healthcare providers are looking at the mental illness. And so we don't want their physical healthcare needs to be bypassed or limited in some way. So again, be an advocate on that. I had a case one time where a gentleman was, sort of showing behaviors, and it was dismissed by that healthcare organization as, oh, it's just the mental illness, and this is how he's acting out, they said. He was actually experiencing cardiac arrest. And so, and then flip it over, sometimes not getting the mental health care that they need due to either physical illness, narrow thinking, or their own disability. So keep advocating. I know exactly how hard it is, and I found it really hard, despite the fact I work in this all the time. One thing to take away and to remind the practitioners of, because the practitioners have restrictions on what they can share with you and collect from you. But in terms of what they can share with you, healthcare provider can always disclose the person's information to reduce or eliminate a significant risk of serious bodily harm. In fact, I better amend that as I send the slides over. So it's to reduce or eliminate a significant risk of serious bodily harm. It's PHIPAA section 40 sub 1. Ask them to, remind them, you know what, you always have the discretion to share that information with any person, including me. And here's why I think you need to. It just, they can go look it up. They can go ask their legal counsel, but that is, one takeaway always. They can share it with any person. And then I know Angie's going to talk about section 7 of the charter, life, liberty, security of the person. Just a note to say the case law in Canada over all these years that's given all of these rights to individuals right up the Supreme Court of Canada is focused on security of the person, the right to refuse treatment, etc., not liberty. And Angie will take that up. And I've already covered the what about the community. So I will stop there, not having looked at a clock, but thank you for the reminder as well.
Thank you, Mary Jane.
And I will stop sharing so Angie can. And this is great while Angie's sharing, just really to pass it over to the lived experience, the what are we going to do with the law? Because it's been decades now. I think mental health and addiction, seniors issues, the caregiver. I mean, there's now a provincial body. It's getting the attention, but we've got to just keep at it. I want it to work at the front line in the law.
Good morning, everyone, and thanks, Mary Jane, for laying the groundwork for what I'm going to cover this morning. Most of my discussion is going to be around involuntary treatment and whether it is in fact a fate worse than death. And I want to start with a bit of a history around these health laws that are in Ontario and some of the problems with the health laws, because I think we really need to validate these rules and these laws are problematic. So back in 2009, the government of Ontario set up an all-party committee to look at addiction mental health in Ontario and come back with recommendations on how to improve the system. And as part of that, they traveled the province, listening to experts, listening to people with lived experience and families. And as part of this, John Gray, who is a psychiatrist and an expert on mental health laws across Canada, testified. And he was also one of 3 authors of a paper called Treatment Delayed, Liberty Denied. And he looked at the plight of patients who had been detained under the Mental Health Act because they were found to be a harm to themselves or others, but they were assessed for capacity and found to have capacity, and then they refused treatment. So this meant that we had a number of patients taking up beds who weren't being treated. And we all know how expensive hospital beds are and in psychiatric facilities. And 2 patients had been detained for 20 years. The record at that time was one who had been detained for 25 years. And again, they were being detained because they were a harm to themselves or others under the Mental Health Act, yet they were found to have capacity and were refusing treatment under the Healthcare Consent Act. So the cost of this to taxpayers back then for somebody who had been detained for 20 years was over $4 million. That was to basically put a roof over their head and not treat them. So he did point out that this could not happen in BC and most other provinces and countries because in other jurisdictions, their laws are, if you're sick enough for us to deprive you of your liberty, you're sick enough for us to treat you. And the best example of this is a case known as Starson and Swayze. And by the way, in all of these slides, if you see bright blue, that means you can click on it. You will be getting a copy of the slides and it'll take you to the resource. So in Starson and Swayze, Professor Starson was found by his psychiatrist to be a harm to himself and others. He was threatening others, and yet he had capacity. The psychiatrist said he didn't have capacity to make treatment decisions. And Professor Starson appealed it. The first thing to know is this decision got appealed all the way to the Supreme Court of Canada. And during that period of time, which of course was years, under our laws, you're not allowed to treat the person. So he was not getting better. At the Supreme Court of Canada level, they held that a mistake had been made and that actually he did have capacity to make treatment decisions. So he continued to be held for about 20 months, at which point he became so ill because he believed every time that he ate or drank, his child was being tortured, and he had no children. And this went on until he was about to die, and they went back to court, and this time he was found incapable. And so his mom, his long-suffering mother, who was the substitute decision maker, consented to treatment on his behalf. He was given antipsychotic medication and released to the community. It wasn't a perfect thing. He did come back a few times, but the point is ultimately he got the treatment that he needed, and was back reunited with family and community. So this is a pretty bad problem in our legislation, that the 2 acts just not working together. So the committee issued their final report in 2010, and they got it. They listened to people and they understood. And they said, hey, listen, there's this tension between somebody's right to autonomy and their right to be well, and society's obligation really to protect vulnerable people. And our laws as currently drafted are tying the hands of health professionals and families, and it's contributing to the criminalization of mental illness. And they said often that's what's needed for people to get care. I would add, often people are criminalized and they still don't get the care they need. And then they pointed out that this is a hugely under-resourced part of healthcare. And but it's also a case where, you know, if you build it, if you have treatment on demand, they may not come because it's the nature of a lot of mental disorders for people to deny that they're ill. And they went on to point out that psychiatric conditions, some psychiatric conditions, and I think here they're referring to psychosis, schizophrenia. I think, frankly, it's probably all of them. It can result in irreversible deterioration in health if they don't get the help they need as soon as possible. And again, pointed out the problems with our laws. So they came out with 22 recommendations on how to improve our system. Recommendation 21 was, hey, listen, please set up a task force to look at involuntary treatment. But they went further and they said there's two things you really need to do as well. And the first one is what we were talking about before. Make sure if is somebody sick enough that we're going to detain them and deprive them of their liberty, let's just make sure they get the treatment that they need so they can return to their community and their family as soon as possible. The second thing is, you will see most of the forms in the Mental Health Act in many places refer to serious bodily harm. And the case law is clear that it's broader than that, and it can include psychological and emotional harm. And a lot of physicians and families don't know that. And so they wanted them to clarify in the legislation that physical bodily harm includes psychological and emotional harm. They also came out with a recommendation with respect to our privacy laws. And this I'm sure will be music to your ears. They said we should be ensuring that the caregivers who do so much in the system have access to the personal health information that they need in order to support their loved one. So that said, again, this was back in 2010. The government of the day in 2011 came out with a new report called Open Minds, Healthy Minds. And they said, hey, you know, those two task forces that we're supposed to set up, we're going to do that. We're going to address these issues. Absolutely nothing has happened on that front ever since. So it's been 11 years of inaction by all the governments of Ontario that have been in power since then. So we've talked about capacity a bit, capacity to make treatment decisions. And there's a lot to know about capacity, and I don't have a lot of time. So just briefly, it is assumed. The physicians are supposed to assume someone, even if they have a mental disorder, to assume that they have capacity. And then there's a two-pronged test. If there's some kind of red flag and they're not sure, there's a two-pronged test. And the first part is the person has to understand the information in order to make a treatment decision. So it's a cognitive test. It's pretty low. That's not usually where people fail the test. Where they fail the test is the second part, which is that they have to appreciate the reasonably foreseeable consequences of making a decision in favor of treatment or refusing treatment. And this is where that Supreme Court of Canada case comes in, Starson and Swayze. It's very important. They looked at this issue and, you know, they said, listen, your loved one, you know, doesn't necessarily have to say, I'm ill and I have this condition and it's a bad thing. On the other hand, if they don't even know that they're affected by the manifestations or the symptoms of a mental disorder, that they are likely going to fail the test because if you don't think you're ill, how are you going to appreciate that if you don't get treatment, you're going to deteriorate or have adverse consequences? If you're not ill, you don't need treatment. And so that is a very important concept to understand in terms of assessing someone's capacity. So that goes to the issue of anasagnosia. And anasagnosia just means somebody lacks insight into their mental disorder. So we know that it is involved in many mental health disorders. And this is just one example of applying the test for capacity and whether someone was a harm to themselves or others. If your psychiatrist says you lack capacity and you're a harm to yourself, we're going to detain you and want to treat you, you can appeal that to the Consent and Capacity Board. And that's what happened in this case, where a 20-year-old patient with an eating disorder was found to lack capacity to make treatment decisions because she had Anasagnosia. She didn't think she had an eating disorder. And so basically she failed the second prong of the test, and her parents scooped in as substitute decision makers. And, she basically was fed through a tube. And so even though she was an adult, it's important to understand that these rules apply to adults, not just minors. So where someone lacks capacity, the substitute decision maker gets to make the decision. So is Anasagnosia a thing with respect to substance use disorder? Absolutely. There's less written about this in the literature. Usually with respect to addiction, it's called denial. But this quote from an article in 2015 pointed out that based on a survey in 2013 in the States, of people with substance use disorder, 20 million there were 20 million people, 19 million of them, or 95%, didn't think they needed help for their substance use disorder. And even 90% of those with withdrawal symptoms like trembling hands, seizures, hallucinations, also didn't believe that they needed care. So Anasagnosia absolutely is a significant issue with respect to people with substance use disorder. And I'm sure as caregivers, what I'm saying isn't going to surprise any of you. What is odd is, the Mental Health Act has really traditionally never been applied to people with substance use disorder. Yes, if they have other current conditions, which they often have. But this led in 2020 to this paper, and I'm grateful for it, by a group of 8 physicians looking at whether the Mental Health Act actually can apply to a substance use disorder. And they said, yes, of course. The criteria number 1 is somebody suffering from a mental disorder. Yes, because substance use disorder is in the DSM. And there are plenty of cases at the Consent and Capacity Board saying that substance use disorder is a mental disorder for purposes of the Mental Health Act. I am not aware of any cases where someone has been treated or detained just because of a substance use disorder, but that's kind of like trying to prove a negative. So there could be one out there, but all the ones I've seen, there's more than one thing going on. And then the second part of the test, can it result in serious bodily harm? And we now know that that includes psychological harm. The answer was also yes. So there's no reason on the basis of these criteria that the Mental Health Act wouldn't apply to a substance use disorder. I have been advised by many addiction medicine doctors that the problem, however, is generally what happens under the Mental Health Act then is if somebody's failing these tests and they're, a harm to themselves or others, the Mental Health Act really requires that they be in the custody of a psychiatric facility. And 1, there aren't enough beds, and 2, that is likely not the right place, not what is needed for people who primarily have a substance use disorder. So if you can imagine, for example, youth, a locked psych ward is a very scary place and probably not the right place for them. So it's not that doctors think they're not a harm to themselves or others, it's that there's nowhere for them to go. We don't have these types of facilities that would be appropriate. Now, if you're wondering, if how come the government hasn't acted on this? Is it because they're afraid of the general public? Like if they fix these problems under our laws, are they going to lose votes from the general public? We do know the answer to that, and it's no. There's an Angus Reid poll in 2021, and it actually reflected the results of an Angus Reid poll in 2019 on basically the opioid crisis in Canada. And it found that 88% of Canadians are in favor of involuntary treatment for adults, let alone minors, with opioid use disorder. Yet really there is very little discussion of changing the Mental Health Act and fixing the problems with it. It's, I would say, a taboo subject in many political and academic circles. So I want to bring in what's happening aside from COVID right now, which, you know, COVID has made everything worse in terms of the drug poisoning crisis. And how bad is it, and who's it affecting? Unlike COVID, which affects older people primarily, this drug poisoning crisis is disproportionately affecting younger people. So in 2018 and 2019, 1 in 6 deaths of Ontarians aged 15 to 24 was opioid related. And right now in BC, drug toxicity is the leading cause of death for those 19 to 39 years of age. So we have a pretty serious problem, and people are clearly a harm to themselves. So I want to turn now to this tragic case of Marcus Gould, and there's an excellent Maclean's article on the drug poisoning crisis, and Marcus is in there. His mother, Tammy Gould, is a part of Families for Addiction Recovery Health Law Reform Committee. Her son at 17 ran away from home. So he was homeless, but it wasn't because he didn't have a loving home. And she tried everything to bring him back home, get him the help he needed. She found at every turn her hands were tied. She was in contact with the CAS, with the police department, with the homeless looking for him. She did find him a couple times, managed to have lunch with him. But at the end of the day, she decided she wanted to try to do a form to get him into hospital and assessed and hopefully treated. So she applied to the Justice of the Peace, and her application was rejected, and he died not long after that. And it was rejected notwithstanding that he was a minor. He was living on the street, which in and of itself is an adverse childhood experience, or ACEs, everybody's heard of ACEs. He was not in school, he was not working, he was believed to be using drugs, and he had other mental health conditions. And I'm pointing this out because, you know, when we don't do anything to protect our children, I just to be clear here, he couldn't have legally purchased a cigarette or a beer, you know, but if he's you know, lost control over his drug use because he's got a substance use disorder, it's all about his right to refuse treatment. Anyway, this young man never got to the hospital. So the problem in our system goes far, far beyond the medical community. It extends to justices of the peace and the justice system. He was clearly a harm to himself, and there was nothing the mother could do, as I said, and he passed. So what is the criteria in Form 2? I was asked to provide this, so I'm doing my duty here, and you can go back and look at the slides. There's 2 boxes. Well, they're similar to a box A and a box B in Form 1 that the physician uses in the hospital to hold somebody for 72 hours to assess them. So the box A then part A is the easiest route. So again, they're looking for someone who has attempted or is threatening or attempting to cause bodily harm to himself, or has behaved violently or threatening to behave violently towards someone else, or shows a lack of competence to care for himself. So it's one of those 3 things. And then the justice of the peace has to believe that there's reasonable cause to believe the person is apparently suffering from a mental disorder. So even though they're not medical experts, they need to use their judgment as to whether they think this person is suffering from a mental disorder that will likely, which means more probable than not, result in, again, one of these three things: serious bodily harm to themselves, to another person, or serious physical impairment. So those are the tests. The second test, which is like in the alternative, it's harder to meet. It's if you've previously received treatment that works, you've got a mental disorder, you're suffering from the same mental disorder. So just know that it's there. You can come back and look at this, but I'm not going to get into it today. So what are the tips for if you're trying to form someone? And the first thing is, and it sounds crazy because I know you're caregivers, but know the law. Because lots of other people don't who should. So the first thing to know is that this risk of harm does not have to be imminent. You will still hear that said. That was a requirement prior to the year 2000. Yes, I said 2000. It's still not widely known. It doesn't have to be imminent. Bodily harm includes psychological harm, and substance use disorder is a mental disorder. We recently had a situation where a family, parents of a 15-year-old were trying to, again, do a Form 2. And rather unbelievably, the Justice of the Peace said, I would love to be able to form your child, but substance use disorder is not a mental disorder. This is wrong. So you need to know that. You need to advocate in case you hear this. So if the first Justice of the Peace, if you try to form and you don't get the result that you want, try for another Justice of the Peace. Like, don't give up. Mention all, if your loved one has been diagnosed with one or more mental conditions, make sure you get that information in front of the Justice of the Peace, their age, maturity level. One of the things I found really interesting is the literature shows for a lot of youth who struggle with mental health and addiction issues, the level of maturity of the brain, I'm really talking about the development of their brain, is delayed compared to their peers. And how do you see that looking at someone? But it goes to sort of magical thinking, not just a lack of understanding of their condition and their situation. It's always important to keep notes of what's been going on in terms of anything that shows your loved one lacks insight into their condition, and that they're a harm to themselves or others, including psychological harm. Here I'd like to throw in, what about risk of incarceration? I haven't seen that raised before, but I am saying, to me, you're at risk of psychological harm if you're at risk of going to jail, and a lot of our loved ones are at risk of going to jail. So if you're coming back and redoing a Form 2 because the first time you didn't get what you needed, point out the differences, the further decline that has happened since then. So anything like, he thinks he can fly, he thinks he can stop cars with his hands, he's wasting away and doesn't think that he's got an eating disorder, those kinds of things. Mirror the language of the Mental Health Act and the Form 2. Talk about safety. You're worried about their safety, you're worried about other people's safety, and it's important to be credible. So don't exaggerate, keep emotion out of it, keep it to the facts. Also important, like if you get the Form 2, what happens is that is basically marching orders for the police within 7 days to pick up your loved one, deliver them to a hospital to be assessed. But there's nothing there that requires them to let you know that when they're picking up your loved one or where they're taking him. So if you can develop a relationship with the police, who would be having to, implement this order, try to get them to agree that they will tell you when they're picking up your loved one and where they're taking them. And then you can beetle it down to the hospital and try to volunteer a whole bunch of information to the physician who's going to be making the assessment. And there, this is all out of your hands. You may never know when he's picked up, where he's going, anything. And again, try for a different justice of the peace if your first attempt is unsuccessful. So if your loved one is, the psychiatrist decides that they're incapable of making treatment decisions, or that they're going to hold them because they're a danger to themselves or others, your loved one will have the right to appeal that decision to the Consent and Capacity Board. And again, there's nothing requiring anyone to tell you that this has happened when the hearing is going to take place. So to the extent that you can have a relationship, let the hospital, if you know where they're at, let them know that if this happens, you want to be a witness, you've got important information. I mean, let's get real. The psychiatrists and other healthcare professionals see your loved one for this much time. 60% of you said you're living with your loved one. You are the expert about all of the the things that they're doing in their day-to-day life that show that they're not capable of taking care of themselves, that they are at risk of harm to themselves or others. As some of you may have been threatened, all of this is relevant. Often in these Consent and Capacity Board hearings, both issues are coming up, capacity and harm to self, others. So again, just keep a journal, a chronological journal of everything that points to their safety, a lack of their safety, a lack of safety for others, and what they say that show that they lack insight into their condition. They don't understand that they're ill. You can, if you get asked to appear as a witness, you can be represented by a lawyer. And there's a really excellent online course by a lawyer, Lisa Feldstein, and there's a link here, Consent and Capacity Board, What Family Caregivers Need to Know. And there's also on the website for the Consent and Capacity Board a mock hearing, and this is a link to it, of a situation. It's half an hour to see what a mock hearing looks like to determine a patient's capacity to make psychiatric treatment decisions. And I think even if you're at a stage before Consent and Capacity Board and you're just trying to form a loved one, it's really helpful to spend the 30 minutes and look at that mock trial. So we know how the laws are supposed to work, and they're supposed to be protecting people who are vulnerable. And it's gotten so bad that this is actually what's happening. So in BC, Ali Thomas, at the age of 12, died from her 4th overdose. She refused treatment every other time she overdosed. Now, it's not entirely clear she made it to the hospital for all of the other overdoses, but it certainly reads that way. And that would mean that physicians decided 3 previous times that she had capacity to make a treatment decision, and that she was not a harm to herself. And so if we're not going to intervene to protect a 12-year-old on their 4th overdose, it's really hard to understand when we will intervene. So it's just really bad. And at least in BC now, they are having a lot of discussions around this. You may have heard of Bill 22, but they did introduce legislation. It died on the order paper. The government changed. They haven't reintroduced it yet, but it would allow hospitals to detain someone like Ali Thomas for 2 to 7 days. Only 2 to 7 days, basically in order to try to stabilize her. And there was a lot of opposition, some of it valid, like, well, what are you going to do after the 2 to 7 days? Because there's nowhere for her to go. Valid concern, but some other concerns I would say are not so valid. And what I'd like to do is really point out the hypocrisy uh, or double standard between how we treat substance use disorders and the issue of autonomy under our health laws versus under our human rights legislation. So most of you may know substance use disorder is a disability under our human rights code. And in 2019, there was a case where a nurse had been stealing pain medications in the long-term care facility that she was working in from her patients, and she was caught. She went to treatment, she recovered, she wanted her job back. The employer said no. The union took the employer to the tribunal. And after looking at and listening to expert witnesses, the arbitrator said, listen, as you know, substance use disorder is a mental disorder, and it's characterized by compulsive behavior and either a complete inability or a diminished capacity to resist the urge to engage in behavior supporting her addiction. So, while this would look to the outside world like something that is really morally reprehensible, she actually had lost control over her behavior around her substance use, which meant not only using, but what she had to do in order to use. And basically, they said the workplace has to accommodate her. So let's compare that to our health laws. So Sunnyside illustrates that our human rights laws are protecting the livelihoods of functional employees because substance use disorders are a disability and they have a detrimental effect on a person's autonomy. At the same time, our health laws, either as drafted or applied by physicians, are not protecting the lives of youth with substance use disorders because of patient autonomy and them refusing treatment. So we hear a lot about, especially in terms of substance use disorder, the buzzwords now are we need a public health and human rights approach. Well, what does that mean, human rights approach? Because I would say there's a lot of controversy about what a human rights approach actually looks like. And this gets right into that issue of autonomy and self-determination versus duty to protect. And it's pretty clear an individual can have competing rights and they have to be balanced. And so this is going right back to what the select committee said 11 years ago. So where a person doesn't want to die and their right to refuse treatment or their autonomy or lack of autonomy, honestly, conflicts with their right to life and security of the person, which should be prioritized. And I always thought truly this was a rhetorical question, but no, not only is it not rhetorical, we now have two pretty significant organizations coming out against any kind of involuntary treatment, basically ever. The World Health Organization and the UN Committee on the UN Convention on the Rights of the Disabled. Their view is basically you're discriminating if you say someone with a mental disorder lacks capacity. So we're going to deem everybody to have capacity. Fortunately, Canada did not, that we took an exemption on certain parts of the UN Convention on the Rights of the Disabled. But you need to know the opposition to involuntary treatment is organized, it's funded, it's powerful, and it's problematic. I love this quote. It's from a 2-page document I encourage you all to read called Uncivil Liberties. And it is remarkable because it is by Herschel Hardin, who is a BC civil libertarian, but I think his views were affected by the fact that he's also the father of a child with schizophrenia. And he said, the opposition to involuntary committal and treatment betrays profound misunderstanding of the principle of civil liberties. Basically, medication frees people from their illness, it frees them from their psychosis, it restores their dignity, their free will, and the meaningful exercise of their liberties. Well said. With respect to minors, we have an additional reason to intervene. There are 3 sections of the UN rights of the child, which Canada has signed. Article 3, all of our laws are required to be drafted in the best interest of the child. Article 24, children are entitled to health care. And Article 33, they have a right to be protected from the use of illegal drugs and from being used in the drug trade. And there's an article that I wrote with a few others, just referring it to there. It's 10 pages long, and it talks about this, because there's no doubt in my mind, currently Canada is violating the rights of our children under the UN Convention on Rights of the Child, who need treatment. And there's a great conference by the University of Toronto and a document that's linked there in 2009 that looked at the best interests of the child. And they said, yeah, you know what? If we're going to put that first under our health laws, we need to change the current models of formal health care. We need strategies to keep kids out of the justice system. And that's why I'm saying, like, that whole idea of psychological harm, including like you're going to be criminalized because you're selling drugs, you're stealing from people, you're acting out and physically harming people when you're under the influence of substances. And that the codes of conduct by the colleges need to integrate the best interests of the child. So none of this has been done. The major opposition to involuntary treatment, I could spend a day on this alone and never take a breath. Well, people think it's unethical, it's ineffective, and it's traumatic. And just so briefly, unethical, I mean, let's talk about Professor Starson for a second. How ethical was it to let him nearly die because he believed his imaginary child was being tortured if Professor Starson ate or drank? I mean, to me, that's unethical. Ineffective, actually, the evidence is that there's no compelling evidence. Nobody can prove it works, prove it doesn't work right now, because we're just, most people aren't getting evidence-based treatment no matter what they're doing. So there's just insufficient research to this. But I would point out that that is the wrong question. Involuntary treatment is designed to solve a problem. The problem of somebody lacking capacity to make treatment decisions, and the problem of somebody who has a harm to themselves or others and isn't seeking treatment. So if you meet those concerns with, but it doesn't work, where exactly does that get you, and what's your better solution? So if somebody is suicidal or they might harm somebody else, involuntary treatment's ineffective. So where does this leave? So just let them harm themselves, just let them harm someone else. This is the solution, and then lock them up, or they're dead and bury them. Wrong question. And traumatic, well, you're caregivers. I don't have to tell you the day-to-day trauma to your loved one and to you when they live in active addiction and untreated other mental health conditions. Interestingly, this just in, a survey of addiction medicine specialists in the States, for the first time, the majority favoring involuntary, there they call it civil commitment. It's basically involuntary treatment for people with substance use disorder. But this means in a specific case. We're not talking about rounding up everybody and doing this. Again, it comes down to capacity, harm to self, others. But they did say, and it was pretty clear, that a lot of them didn't even know if their states had involuntary treatment laws. And by the way, 37 states have these laws where families are allowed to intervene. And so they said, we need more education, research, and that is true there and here. So
Angie, I'm going to give you 5 minutes.
Perfect, that's perfect. So one last example. This is the family of Elliot Urchuk, who died a few years ago at the age of 16 of an overdose in BC. And this to me is the example of just worst case scenario in terms of the treatment of caregivers by the healthcare system. So their son was an athlete. He had a lot of injuries and he got addicted to his pain meds. There were lots of issues regarding privacy. There was an inquiry after his death. And it was heartbreaking because the conclusion was basically, hey, we need more resources. But they'd actually been asked to look at the issue, of involuntary treatment, of our privacy laws, and they just completely bypassed everything that mattered. It was heartbreaking. But not long before Elliot died, his mother mentioned to the social worker in the hospital that they were thinking of taking Elliot to the States for treatment against his will because he was refusing treatment, and they feared for his safety. And in the States, by the way, in most states, parents can consent to treatment on behalf of their children under the age of 18, which is not the case in Canada at all. And the social worker threatened her and said, if you do that, I'm going to look at pressing charges against you for kidnapping your child. So he did not go, and he passed away shortly thereafter of a fentanyl overdose at home in bed. This to me is the ultimate in a lack of respect for family caregivers. And when it's, if it is illegal to try to save your child, there is something drastically wrong with our laws. So where does this leave us? Even if you've got a minor who is addicted to hard drugs, fentanyl, we need safe injection sites and a regulated supply, because that's really all we've got. The treatment on demand is so bad. At Pine River Institute, the wait is 14 months, and there's 200 kids on the wait list. The ministry did just announce 30 new beds for them. Awesome. Now the wait list is 170 because they have long-term care. It's like 14 months is the standard stay. So I'm not expecting it to go down below 170 anytime soon. So there's no residential treatment on demand, and there's no ability to intervene. And if there was an ability to intervene, see one above, there's no residential treatment on demand. So this is where we're at. And does it make me happy? It does not make me happy, but it's better than nothing. And we're not having these discussions, right? We're not having these discussions. So how to advocate? As Mary Jane mentioned, to the extent possible, volunteer information to healthcare providers. There is an issue. I'd love to be able to tell you they have to take your information. They actually don't have to take your information, especially if your loved one has not consented to disclosing anything. Then they're going to have to use the things that the small exemptions that exist, like they can't otherwise get the information in a timely manner, or they're concerned that the information they receive is not reliable. But a lot of them don't know that. So just go with that and just keep volunteering that information. Just keep talking, not emotionally, just the facts and what they need to know. Again, take notes about lack of insight, harm to self, others. Keep talking about safety concerns. Put your concerns in writing. The nuclear option is put them in writing on legal letterhead, get a lawyer to do it. I would say that as a last resort. You really want to work, you want to be part of the treatment team. You want the providers to treat you like that. And remind the provider, if the patient refuses, they should be asking them from time to time throughout the course of treatment. It's not like one and done, that's it, and make sure the provider knows and that they're informing your loved one that generally outcomes improve if caregivers are involved. Know the law. We've been through that before. Be the squeaky wheel, advocate, never give up. So all that's with respect to you advocating for your loved one. But as you can see, we need systemic change here. There's huge discrimination. And you may want to look at the Ontario Family Caregivers Advisory Network of CAN. You can join as an individual, or your family advisory council can join. And that's what it is. It's a network of family caregivers trying to improve outcomes for our loved ones. And also Families for Addiction Recovery, which to my knowledge is the only organization that is advocating for involuntary treatment as part of a continuum of care, as part of the solution for some people, some of the time. And there's 2 pages of references and resources here, all clickable. I do want to point out this first one because it was actually yesterday, good timing, a presentation by Richard O'Reilly, who is an Ontario psychiatrist. presented at the 10th anniversary of Home on the Hill, which is a home for people with serious mental illness and provide support to their families. And the topic was why the system fails families and what families can do about it. It's a good complement to what we talked about here today. He can provide insight that I can't provide because he's within the system. And he also talked about, how to write a letter and get action. So outside of the law, outside of forming, like what's the best way if you're not happy with what your service provider is doing, what's the best way to write to them and say, hey, let's sit down and talk about this. Thank you.
Thank you. Thank you so much, Mary Jane and Angie. So much great information and practical strategies for everyone. And you can see, I can see the chat is flowing. We've got a ton of peer support happening. We've got Mary Jane giving us expert answers to questions. We've got resources happening between our audience. So we will absolutely be sharing those with everyone after the conference. We do have a few minutes here for questions. So I want to allow folks who want to ask their question live to raise their hand using the reaction button at the bottom there. And then unmute yourself and come off. So we'll give folks a minute for that. I can see Tracy has her hand up. If you're willing to unmute yourself.
Hi, thank you. Thank you, everybody. I just have a question regarding consent, especially with children of, say, 12 to 16 years of age. What is the age of consent for that age?
A couple of different things. So unfortunately, the test isn't the same depending on what it is. So very specifically, as Angie had mentioned, and you'll talk more about this next week, under the Healthcare Consent Act, there is no age. You go to Section 4, it's that legal test that we both alluded to. It's all about the person's ability to understand the information they're being given, let's say about a proposed treatment, or for some of you, if you have a senior in your life and you're talking about admission to long-term care, same test, PHIPA test in terms of flow of information, same test. So it's all about the ability to understand the information, which sometimes people are quite sophisticated and they absolutely do. And then the second prong of the test, as Angie said, it's the ability to basically apply it to themselves, to appreciate the reasonably foreseeable consequences of saying yes or no to what's on the table. And she said that, quite often you pass the first prong, but then it's the second prong that's really problematic, right? So many people lack insight, and that is where they reasonably should fail the test. That's often where someone falls down. And so, if we turn that to something really practical, go to that prong of the test and push the practitioner, if you have an avenue into the healthcare provider, to say, look, they're able to understand the information, sure, but they can't apply it to themselves. They're not cognitively able. That's the way they would flunk the test, if you will. And then one thing to consider is if you are a substitute decision maker for that person for treatment, you automatically become the PHIPA substitute decision maker. When we drafted PHIPA, we made sure you didn't have to go back and forth. So if you're an SDM for treatment, you are the substitute decision maker for the information flow as well. And again, sometimes you're going to have to remind the practitioner of that. If there's no treatment on the table and it's only about who gets to decide what information gets collected, used, or disclosed, then you go to those rules about kids. If you're under 16, child or parent. If you're 16 or over, it's the child. If it relates to their treatment under the Healthcare Consent Act or counseling under the Child Protection Statute, they get to make the decision. Even if they're under 16, and this is just on the information flow, then it's the child's wish prevailing over the other. So maybe go back to that first thing. And again, you've got another session next week to create some scenarios on that front.
Just
in other words, there's no concordance between the two statutes. We have age in PHIPA and we have no age, but cognitive capacity in the other. Sorry, Angie, I didn't mean to cut you
I
off.
was just going to add, like at a high level, it's basically, even when you're dealing with minors and because there's no specific age, it's up to the physician and their discretion about whether the child has capacity to make treatment decisions
Exactly.
or not. So in the physician's discretion. So again, every information that you can get in front of them that shows that they lack capacity, which is again insight into their condition, or that it applies to them, or all the evidence that they're a harm to themselves or others,
that they can't apply it to themselves because of their sort of cognitive
and I would add, I believe this is an area for improvement for the medical community in terms of education on what addiction is, that it's primarily a lack of autonomy, because doctors get beaten into them that, patient autonomy. Like, for example, just think of like chemo for cancer, right? Like, they might know, hey, if you do the chemo, there's a 99% success rate. But, if the patient says, I don't want that, they have to respect that patient autonomy. So they're used to letting patients make decisions that could harm themselves. The problem is if they're not well educated about addiction, to know it's a mental disorder that affects your autonomy. And, it's that thinking. I could tell you, like, a lot of people with substance use disorder, especially if they're youth, they can't afford their addiction. It's an illness with a price tag. And so a lot of them are involved in either criminal activity or stealing. Something bad harms others to, do this. And it does, how do we incorporate that to ensure that they don't end up in jail? They don't want to go to jail. They don't want to die. But the only thing scarier to them is a day alive without their drugs. That is the nuclear option for them. And so that's the same thing as saying, abstinence-based treatment. That's a day alive without. So that's their disability, right? And these are the conversations we need to have.
Thank you. And thank you, Tracy. Lucille, I see your hand up if you want to jump in.
Yeah, I just wanted to make note and see if this would be something that you would condone or approve of. My husband, when he goes into hospital, it's always my fault, correct? When he's well, I'm the best person in the world. So, and I've had him pull consent several times on a daily basis. Okay. So last time he was in, he thought of this idea to save myself and save himself. And we carry around a little card that he had formed. And it says, I, so-and-so, being of sound mind and body at this date, wish to appoint blah, 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 phone number, address, to be my advocate and SDM for any medication dispensing, medical and personal information. This overrides any other forms I may sign to the contrary upon entering any hospital. He has signed it, dated it, and it's witnessed. And we carry that in our wallet, each one of us. So we have not had to use it as yet, but it's there in case need be. Now, my lawyer said that it was a good idea. I just wanted to know if you guys thought that that would be an option for some people.
So I think you're talking, I was going to put it in the chat. It sounds, and I don't have the clause in front of me. I think you're talking about the Substitute Decisions Act, and there's something that we sometimes call a Ulysses contract. And I always get the Ulysses story wrong, right? The mythology of the person who said, don't let me crash the boat. Like, I don't want to follow the sirens and crash into the rocks when you bind me to the, I don't know, the mast of the boat or something or other. I never quite get it right. But basically, it's saying, I'm telling you now while I'm capable what I want in the future, and I'm willing to stand today capably and say, take away my right in the future, don't listen to me. I mean, it's not exactly what it says. It's very legal language when you get, it's either section 50 or 51-ish of the Substitute Decisions Act. You can always look it up and give you the right reference, but raise it, I mean, Google it first, raise it with a lawyer. It's a pretty heavy thing for me to say today, but for someone who's been through the process, mean, I've had consent capacity board hearings where, you know, a person with a big professional life descended into mental illness, lost a year and a half as they kept fighting and, you know, obviously exercising their rights. Parents applied to the consent capacity board to be a representative. It went on and on through the courts. The psychiatrist, the attending at the time, was just beside himself as to the time lag. And I think maybe eventually, once capable again, once he had treatment, recognizing what had been lost, that it was at least an option to get what we call a Ulysses contract in place. But you would definitely want to get some legal advice for anyone who's considering that. Like Ulysses, in future, when I say this, don't believe me, carry on past the rocks. So it's an option for sure.
I
Thank you.
just found it very convenient right off the bat when you go
It's not used a ton either.
No, it's
I didn't
not,
even
but there are
think, it's been a
times.
while since I've thought of it. So I'm really glad that you raised it. Just, you know, investigate that, because it might be something that, again, we see people doing it once there's been a real cycle of devastation. They're giving up their legal rights in future in a given situation, usually that they've experienced in the past that has cost them and everyone around them, if I could characterize it that way.
Okay, thank you.
Thank you, Lucille. And thank you to you both, Angie and Mary Jane. We have run out of time. We are so lucky to have had both of you take your time this morning to come out and join us. And we're so grateful. Thank you very much. I want to just remind everyone that I know we had a few questions and we were unable to get to them because we ran out of time, but please type your question in the chat, because those of us who are working in the backgrounds are going to grab those questions from the chat and we're going to get you those answers, and we're going to send it to everyone in an email communication, and we're going to post on our resource website after the conference. Thank you very much. We're going to take a 5-minute break.